So it's time for another question and answer session. I didn't intend to hold these as regularly as I have been, but I get so many questions, and if they're good and illustrative questions, I think it's useful to have them here because that way people can see the answers rather than just me typing out an answer in the comments that people may never see. So I'm going to try and rattle through these as quickly as I can today. We'll see how it goes. I may need to put a few things up on the screen just to illustrate things, but I'll try and give a straight answer where possible. So without further ado, the first question is, the catalogue of errors in the treatment of these poor babies is truly disturbing. Have they all gone on regardless caring for babies? Do we know if they have had to address their own inadequacies or face any disciplinary questions themselves? So I have to be very careful talking about this topic because it's somewhat contentious at this point in time. I think that with a hospital, anyone involved in medical care, anyone involved in healthcare, any medical department should be constantly challenging, questioning, refining its own processes. So that should definitely happen. After they have this string of babies passing away, collapsing, all the rest of it, there should obviously immediately there should be red flags, and they should be looking at themselves, and they should be looking at their processes, they should be looking at the environment. That should happen immediately. Obviously we know what actually happened, so whether the unit has been willing to address its own inadequacies, as you put it, I don't know. I don't know the current working status of people involved. I wouldn't wish to speculate on that, but I've heard a few things. I couldn't give a definitive answer, and the hospital naturally has shrouded itself behind a curtain at this point. Whether they would face any disciplinary questions at this point in time, Lucy Letby has killed all these babies officially, so they won't face any disciplinary questions at this point in time. Question 2. In Mark MacDonald's first press conference during December 2024, he mentioned that he was in tandem with the CCRC application going to write to the Court of Appeal directly to ask them to consider taking another look at the request for appeal. The reason being that the CCRC predominantly considered new evidence, whereas in this case there was also a matter of the courts, and the Court of Appeal themselves being misled due to the prosecution's star witness changing his view on the method of murder. And then he goes on to say, I've never heard a mention of this since. One may assume that the Court of Appeal rejected the request and advised that the only recourse was via the CCRC. I wondered if the response made it into the public domain or if it was something that you had any knowledge of regarding the outcome. So I can answer those two questions. Firstly, it didn't make it into the public domain. It's never been mentioned since, as far as I'm aware. I don't have any knowledge regarding the outcome. What I can say is that it was always likely to be unsuccessful. In any kind of rational universe, obviously it would immediately have been successful, but in any kind of rational universe, Dr. Evans wouldn't have been in the court case. So I think it was always an unlikely legal argument. Mark MacDonald conceded during the press conference that it would be, I don't know if it had even happened before, I don't know if he used the word unprecedented, but it would have always been unlikely to occur. I didn't think it was likely to be successful because it's not something that usually happens legally. The fact is, if the judge didn't throw him out of the court case, he had that information. He didn't know about. Well, he did. He did know about the changing of diagnoses because he did it in the court case. So if he's gonna get a letter saying he's worthless, it makes no effort to give a balanced opinion. And if he's going to watch him change his diagnosis in the court case, and he's not going to throw him out of the court case, it's very unlikely the Court of Appeal are going to do it. So just legally, I think this was never going to happen, even though it's frankly a perfectly legitimate argument. In your opinion, why do you think Lucy didn't instruct her defence to get the appropriate experts to challenge the claims made, as it has been mentioned that Lucy made that decision? Well, all I can say to that is I'm derisive of the idea that Lucy made that decision. What happens usually, in any usual scenario, the barristers will be consulting with Lucy and will be helping her. Now, for something like this, which is strategic, the barrister will say, look, you have two options here. We can get people on the stand and we can have people in the witness box, experts, or we can not have people in the witness box. Here's why I think we shouldn't have experts in the witness box. The idea that Lucy is running her defence when she knows nothing about the legal system, she's never been in a court case before, she's in prison at the time, remember? She's incarcerated. She's obviously broken down mentally and psychologically, and this is a court-appointed barrister. So I dismiss the idea that she made this decision. I think it's utterly ludicrous. I would ask anyone to put themselves in that position. Would you run your own defence strategy, or would you do what your court-appointed barrister advised you to do? Literally everyone in the universe with any sense would follow what the court-appointed barrister told them to do. So the idea that Lucy has made this decision is, in my view, just utter nonsense and just something that doesn't even really merit any credence whatsoever. Didn't the GMC state they wouldn't be responding to the complaint, suggesting it was outside their remit as the public inquiry was taking place, / CPO still have more cases to decide on, I assume? So I don't really know anything about this. Clearly, I'm not quite even sure what you're referencing. All I'll say about this as a broad comment and response to this question is the General Medical Council don't get involved in anything. So people have made complaints about Dr. Evans, for example, which are surely now completely reasonable. The GMC have done absolutely nothing. So, once you get a controversial issue such as this, a major body such as the GMC has to have internal meetings. They have to seek legal advice, and what they will always do is take the path of least almost always, I should say, take the path of least resistance and just do what is the easiest thing to do, the least controversial thing to do, the least contentious thing to do, the less legally damaging or challenging or precarious thing for themselves to do. It's as simple as that. That's the way all organisations work. All organisations and institutions have institutional protection built into them, both in terms of the way things are actually documented to work, that are manifestly written down, and also on a day-to-day, you might describe as an anecdotal basis where people just think, should we do this, should we do that, let's do that, it'll be easier. That's just the way organisations work. Anonymous witnesses at Lucy's trial. Reasons cited include mental distress, stress during trial, and unwelcome press attention. These reasons, along with others, don't come anywhere near the threshold required. For example, threat of violence or retribution against witnesses. Would you be able to add this to your next Q&A video? Many people have observed that there is a very unusual number of anonymous people involved in this court case. Now, I don't know what the justification given was for that, and there have been media articles about this, but the police seemingly demanded it, and the prosecution perhaps. There's never really been an explanation. There's never been a public explanation for why so many people are anonymous. It is justified for the babies to be anonymous. Absolutely. There may be other circumstances where other people are anonymous. Why doctors working at the hospital are anonymous, I have no idea. But given that this could be something the police requested, it can be something that the legal system, the prosecution requests, and then it's just granted. So those sources, once the witnesses are anonymous, will say, we can't reveal the reason why we requested this and we won't do that. Not that the police will ever answer any of your questions, of course. They steadfastly refuse to do that. So we will never know why these witnesses were made anonymous. We will never know, well, if and when Lucy's exonerated, and there will be a massive inquest and investigation into this, at that point, someone might ask the question of why so many people were made anonymous, and that question may be answered. Until that time, we will simply never know. All I can say is that I agree with you that it shouldn't come near the threshold required, but it was allowed, and now we've got no way of finding out. It has been asked in other comments why the jury bought Evans' testimony. I think they heard he was an expert, then heard him spout a load of medical jargon that they probably didn't really understand and thought, well, he's an expert, so he must know what he's talking about. If the defence counsel had hammered him on that point, that neonatology is a distinct specialisation requiring 3 years of additional training, that would perhaps have called his expertise into question in a way that would have made sense to the jury. Anyway, it's just one of many missed opportunities by Letby's lawyers. I find it very frustrating to think about. So the first thing that I would say is that I don't think the verdict was anything to do with Evans' testimony, because Evans' testimony was very weak. He gave a very poor account of himself in court. This is one of the many things that I want to get into in the future. I'm never going to run out of material for this channel. If I could get all the court transcripts, we could go on forever analysing things, but certainly we hope to get Lucy exonerated as soon as possible. But if in some horrible scenario she was still in prison 10 years from now, I will still be making videos because there is so much to go over. It's insane. I haven't even done 0.1% of the court transcripts that I've got, which isn't even half of the court case. And who knows, I might get hold of more in the future. There's all kinds of things that can still happen. But I've done little bits and pieces of Evan's testimony. It wasn't strong, and I don't personally think that was the reason that the jury found Lucy guilty. I think the reason is quite straightforward. Firstly, they were told she was always on duty, and it could only be Lucy Letby that committed these crimes. Secondly, they were given the insulin cases, and they were told someone has definitely been poisoned on this unit. So Lucy said, fair enough, but it's not me. But the shift chart has already said, it is you, Lucy, because it can't be anyone else. Now, of course, we know the inaccuracy of that now. But I think those two things together are massive, and then they put a note in court and said, look, she confessed. So they put the three things together. It's always what I call it's always Lucy theory. This is always on duty. Someone has to have poisoned a baby because look at this evidence. That's irrefutable. It wasn't properly challenged in court. And they made Lucy say, well, okay, fair enough. If you say experts have poisoned someone, I can't argue with that, but it wasn't me. But then the shift chart says that it is. And then they said, oh, look, she said she did it anyway. So I think that is really what convicted her. I think it's nothing to do with Dewi Evans. So I totally agree with you that they could have, but I don't know. I don't know what is normal in court. I don't know. Would you question the credentials of someone? They did. Ben Myers did question him on the worthless letter and did a reasonably good job of it. I do think he could have questioned him on the neonatology point quite strongly. But even if he did that, the jury is still sitting there. We just heard in a recent ITV documentary, Josh Halliday saying we couldn't believe it when they didn't bring any defence experts. So even a paediatrician, at the end of the day, he's a qualified doctor. They never heard from any defence experts. So I think it was an open goal for the prosecution. I think, frankly, I could have won this case because it was so skewed against Lucy. I'm sure I could have maybe I'm not saying I'm as good a barrister as Nick Johnson. He's highly trained. He's been doing it a long time. He's used to getting up in front of a court and speaking. Obviously he's skilled at what he does. Whatever we may think about him as a human being, and I don't necessarily have a huge opinion of him. I'm less critical of him than others in the case, but I'm confident I could have got convicted. If I'm just going to say, right, we've got 100% proof of insulin poisoning. Secondly, we've got a note that says you confessed. I don't think I could ethically or morally present that in court as a confession, but anyway. And then thirdly, you're always on duty, so it has to be you. I'm pretty damn sure I could get her a life sentence, and I think any competent barrister would. So I think that is what convicted her, not Dewi Evans, who did not do well in court, contrary to his own opinion. The recurring theme for me is why was ultrasound not used to locate free abdominal fluid if there was any before and during the procedure? Wasn't an ultrasound machine available, or was the problem that no one was able to operate it? Alternatively, was it a time issue, and if so, why didn't they use the safest option of the LLQ? I had no idea people were arguing that it's okay to use the RLQ, especially in neonates under high pressure ventilation. Are the papers you refer to based on studies in adult patients? So let's take the last question first. So this is referring to a paper that is talking about inserting a needle McBurney's point and showing that you shouldn't do that. I'd have to go through every individual study, but there are definitely studies in neonates and infants that indicate that you shouldn't do this. I mean, this is standard. This appears to be standard practice, so I can answer that question. The other questions here are a little bit above my pay grade. So I asked Michelle Warden when I interviewed her, can you see a good reason why Stephen Brearey didn't use an ultrasound machine, didn't use imaging? And she said perhaps he panicked, perhaps it's the pressure of the situation, perhaps it was a time issue as you suggest. As to why they didn't use the safest option of the LLQ, I can't answer that question. I just cannot answer that question. That is above my level of understanding. If I was to sit here and speculate about it, I'd have to go away and do a lot of research, and even then, I still don't think I could really answer that question. That's really a question for surgeons. I just don't know. I personally, as a non-qualified person, find it very strange that you wouldn't use imaging. And also, I've mentioned previously, I've undergone an operation in which imaging was used, laparoscopic fundoplication, where you have keyhole surgery on your stomach. And obviously imaging was used. I put to sleep. Obviously, it's not as urgent. I wasn't about to die or anything. So that could be a good answer from Michelle. I mean, Michelle knows everything. If there's something to know about this case, then I don't, if Michelle doesn't know it, it probably doesn't exist. So I think her answer is very credible, and I would probably refer you to that. Another fine dissection of medical information, Chris. Since learning something of the available facts, it seemed highly unlikely to me that Dr. Stephen Brearey is on very vulnerable ground for his medical practice here, and he would be aware of that. Did Lucy Letby reference his apparent recklessness, and did this seal her fate to be scapegoated? So I have to be very careful about answering this question because it's currently contentious. So I don't think that it's very likely that Lucy's made any reference to mistakes. I'm not sure. There's going to be a question later on about whether or not she was deliberately scapegoated. I don't have a good answer to that question. I'm not sure that she was deliberately scapegoated. I think Dr. Stephen Brearey and Dr. Ravi Jairam absolutely believe they're correct. I think they believe Lucy Letby was behind what occurred on this unit, and I don't think they used her as a convenient excuse to brush their problems under the carpet. I personally do not believe that. I've got a section in my book that discusses this, and I've got some quotes from a very high-ranking person who has given his view on what he has seen in some very high-ranking institutions similar to this. So I won't spoil that because it's kind of an exclusive, but what I would say is people are prone to self-serving opinions. If we're all prone to that, everyone, no matter how much you try to be objective, no one is truly objective. It's a delusion to believe you can be truly objective because there's all manner of biases we have. There's all manner of we tend to be self-serving. Of course, we act in our own interest. Now, hopefully, the better people among us try to be objective and try to see things in an unbalanced and unjaundiced perspective. But we're always going to take on views and perspectives that serve our own interests and that are consistent with our general worldview. That's just normal. And there was a big incentive on this unit. I believe Dr. Stephen Brearey, Dr. Ravi Jairam and others absolutely sincerely care about the performance of the unit, and they're all paediatricians. Dr. Stephen Brearey is the paediatric lead. I don't believe, not for 1 second do I doubt the sincerity in wanting to get good results from the hospital, and I think it's very important for us not to lose sight of that. I think when things are going very, very badly wrong, as it occurred in this scenario, there's always going to be a self-serving tendency for people to think, right, well, it wasn't me, obviously, and it wasn't us as a group of paediatricians, a team of paediatricians. And then when you have a scenario where it is unusual and it hasn't happened before, then all of a sudden you can start to think certain things, and then that view can become like a stone rolling down a hill, and suddenly it's unstoppable. And that is, I think, essentially what's happened here. But that kind of overlaps with another question, so I'll probably reiterate that later. What were normal arrangement for paracentesis on the unit, and was this followed? I simply don't know the answer to that question. I don't think there's any way for me to find out the answer, unfortunately. When was radiology and surgery not contacted, or why not? Why is this being done on a rapidly ventilated baby? Needles in an abdominal organ oscillate on insertion along with the breathing cycle, failing which, if they are held to aspirate through and not immediately removed, they tear the organ. On a wider basis, what was the purpose of the test? Why was the right side used? Why did Dr. Evans not mention this? And why wasn't the coroner and pathologist communicating that it was done? Did the procedure cause ascites? Or is that how it's pronounced? I looked this up as well. Ascites, is it? Or ascites? I'm not sure. Sorry. I'll have to go away and look that up again. As a result of fresh bleeding, which is a cause of fluid outside the bowel. So let me go through the questions that I can answer. So when was radiology and surgery not contacted, or why not? No idea. I don't think anyone can answer that question. I don't think we know why this didn't happen. Why is this being done on a rapidly ventilated baby? And then there's some technical explanation of this. Again, I don't think you'd have to have a medic to try to address this. We discussed this with Michelle. If you go and look at, if you haven't seen this already, if you go and look at Michelle's interview, Michelle Warden answered this question quite well. And it's clear that there were many failings on the unit with this infant. This is Child O, of course. On a wider basis, what was the purpose of the test? I believe it's to remove fluid, simply to remove fluid. Why was the right side used? No one knows the answer to this question. It seems to be simply a mistake. Why did Dr. Evans not mention this, and why wasn't the coroner and pathologist communicating that it was done? Firstly, Dr. Evans won't know, more than likely. It's quite possible that he's never done this. It's quite very likely that he doesn't have the medical expertise. So I showed a whole list of academic papers. Many of these academic papers were recent. So it's quite possible that he just simply does not know this. I mean, the body's a very complicated thing. Medicine is very complex. Surgery is complex. He has a lot of knowledge. You know, we shouldn't knock his ability. He was a paediatrician for a long time. You can't do that without knowledge. But he's just nowhere near up to the standard required, and his knowledge is not up to date. So that is probably the most likely explanation. I cannot speculate on why the coroner and pathologist weren't communicating, or why they weren't informed, etc., etc. It's not right for me to speculate on this, and frankly I could get myself into hot water, so I just won't answer that question. Thank you so much for your analysis. I was wondering if you had any thoughts on the Supreme Court recent criticism of the Court of Appeal with regard to the bank trader conviction. Supreme Court seemed critical of the Court of Appeal's stubborn refusal to even hear new legal arguments, never mind rule on them. Would this criticism affect the Letby case? So first thing I'll say is that the gentleman involved is called Tom Hayes, and I have met him. Very lovely guy, and I know a little bit about economics and finance and banking, as I perhaps made clear when I was analysing Dewi Evans' opinions on the Welsh economy. So Tom did explain to me a little bit about this case, and I do know a little bit about it. He was essentially, his convictions were quashed on a legal argument. So the legal argument was that the court at the time, or the judge at the time, failed to properly instruct the jury. So what I'll say as well is that Tom was released from prison. The reason he was released from prison was because there was another conviction in the United States that was overturned, and he was essentially accused of doing exactly the same thing, so it just wasn't tenable anymore. The reason he was out of prison, trying to be, he's not in prison, so he's not going to go in prison again, but he was still trying to get his convictions quashed, and still the Court of Appeal refused to hear new legal arguments. So that tells you how difficult they make it, how high the bar is, and the challenges that Lucy is going to face. And that's why public pressure is so important in this case. In terms of whether this criticism could affect the Lucy Letby case, I don't know, is the simple answer. No one knows what the Court of Appeal are going to do. Certainly they're sensitive to public criticism. They would claim otherwise, but every single organisation is sensitive to public criticism. So it could. What I would say is that Lucy cannot get out of this, and she cannot get out of prison through legal arguments. In this case, the judge made a genuine blunder that could have resulted in Tom being found not guilty. Ultimately, he's been released anyway, but this is to quash his convictions. Now, I've been told by someone that Lucy just cannot go down this route. I don't know if that's true. I wouldn't like to say, and I'm not. This could prove to be completely wrong. In the future, she may be exonerated by the Supreme Court. I don't know. But so typically the Supreme Court deal with process, and they were able to make a process-based argument to the Supreme Court. So I'm not sure if that helps Lucy or not. I couldn't possibly say. Put it this way, it can't do her any harm. What intrigues me is that there were 4 doctors, including phone opinion of Arrow Park neonatologist, involved in decisions about baby O at that time, but there appeared to be no questioning of the site chosen. This is for the insertion of the needle. This seems strange if it was known to be unsafe. It was also noted that a small amount of blood was obtained. Do you have any observations about this? So what I would say is it's perfectly possible that they don't know that it's unsafe. And there are a small number of documents that say you can insert the needle on that side. Overwhelmingly, there are more documents and more studies that say you should not do this and give specific reasons why you shouldn't do it. I don't know what kind of training these people go through. I don't know what kind of preparation. Things happen very quickly on a neonatal unit. It's very easy to get things wrong. I should imagine that's no excuse when it happens, but it's not easy. And I always try to be fair. Yeah, the fact is, I've never been in a life or death situation where I have to go in and put a needle in, or aspirate a small baby. It's very challenging, testing, and I'm sure stressful and some often traumatic work. And we shouldn't be too hard on the people on this unit for making mistakes. Obviously, people that are medically qualified who go through this type of work, they're much better placed than me to be critical. I am critical when I feel it's justified and necessary, but I don't want to be. I want to be measured in my criticism, because the fact is, I've never been in an operating theatre. I've never picked a scalpel up in my life. Now, there are certain other people who comment on YouTube. My comment about one of them was, she's never even seen a scalpel before. I'm aware that I've never even seen a scalpel before, so I'm very careful and measured in my comments. Or I try to be. But it's the simple answer to the question is it can just be a cock-up, basically. None of them may have known it was unsafe, or none of them may have known it's not standard practice. That, in my view, is the most likely explanation. Correct me if I'm wrong, but didn't Dr. Evans tell the CPS when touting for the lucrative position of medical expert that this is my kind of case, or words to that effect? That's absolutely correct. It would be interesting to uncover the timeline of Dr. Evans' involvement in the case and compare it with when it was first known that staff nurse Letby was the suspect. So I've done this to a certain extent in a recent video, so you may have seen this by now. The police must have used an expert to advise them whether or not the babies were in fact murdered. Who was that expert, and when were the police told? So Dr. Evans was definitely the expert that advised them of this. On the 15th of May 2017, Dr. Brearey and Dr. Jairam had a meeting with Nigel Wenham of Cheshire Police, and they said they had suspicions, and they said they suspected a nurse. They never said explicitly that there was malignant behaviour. In my view, what they did was unprofessional and wrong when you know the full story of what happened at the hospital, and the police should have engaged in a lot more due diligence than they did, and they made mistakes, and now Lucy Letby's paying the price for that. But absolutely, Dr. Evans was the person who he told them and he advised them. I mean, they basically put it in his hands and he ran the whole thing. That's absolutely true. Surely it would have been the very first thing on their agenda and known before she was first arrested. It is inconceivable the police would have arrested her without knowing if an offence had actually been committed. So by the time they arrested her, according to the account of Dr. Evans, he had submitted something like 90% of his reports. First reports. He amended them numerous times, but he had submitted most of his first reports when she was arrested. So basically at that point, they've got someone who describes himself as a consultant paediatrician. He works for the National Crime Agency. He's done a lot of work before. The police think we've got a perfectly credible medical expert, and he's doing the work that's needed to be done. The police don't know how to run a medical investigation. They've made an absolute pig's ear of it. And they don't know that Dr. Evans is as unreliable as he is. Again, they could have done their due diligence. It seems that they did not. I mean, I certainly believe that they did not. So essentially, Dr. Evans says, right, we need to come in and call in this person, that person, that person. So the police might have thought, oh, look at us doing a multidisciplinary review, if they know what multidisciplinary review is. There's indication in some of the documents from Thirlwell that they did know that. But there's a big difference between hearing the phrase and actually understand what it looks like. I know, for me, I would not attempt to run a multidisciplinary review on my own, clearly, and just say, oh, here's a doctor, right, he says we'll do this, right. You need a lot of advice, you need a lot of assistance, you need a lot of people. you should seek a second opinion, obviously. They just didn't even do that. They just got Dr. Evans in. He told them what to do. He ran it. He said, right, we need to hear from a radiologist, etc., etc., and they just let him run the whole thing. They probably, to this day, think they ran a legitimate multidisciplinary review, and they just don't know that they did. So the final comment is to give a full timeline. So we don't know the exact dates that Dr. Evans contacted the police, and he claimed, I didn't contact them, it was another matter, but basically he did. He contacted them through the National Crime Agency between May and July 2017. We don't know the precise date because his account changes. At the latest, it was July 2017. The suspicions of the police began on the 15th of May 2017. Then Dr. Evans, so they obviously commissioned, they said, Dr. Evans, so Dr. Evans walks into the police station on whatever date it was, possibly July 2017, and then he walks in there and he immediately says, within 10 minutes, there's definitely inflicted harm. He actually said in the recent BBC documentary, within a few minutes, so it's shortening every time. So, but anyway, he's immediately gone in there and said there's inflicted harm. So at that point, the police are going, wow, there must be a crime here. And then they just let him go away and look at all the notes. They gave all the notes over. Then he handed in his reports and he said there's been a crime. You just need to go. His words were, before they arrested Lucy, this would have been in 2018. We don't know the precise timeline. If someone's on duty for lots of incidents, you've got a suspect. That's what the police did then. Then they've got a suspect and they arrested her in July 2018, I believe it is. And that is the timeline. And then Dr. Evans, definitely knowing the name of Lucy Letby, mucked around with the cases for another few years until he'd figured it out, I believe his phrase was, in one interview. So that hopefully that's a full timeline and that answers your question. Why do you think they, all of them, contributed doing this to Lucy? Why has she been scapegoated? Why? Very good question. I kind of answered this earlier. The first thing that I would say in answer to that question is, I don't know. I've really tried to understand why they would do this. And people have made various comments about this being calculated and her being scapegoated and them having feeling resentment towards Lucy and so forth. I understand those arguments, but I don't think that they're correct. And the reason that I say that is that no one can point to anything that is enough. So yeah, Lucy filled in some Datex forms. She might have been a bit more diligent than they like a nurse to be, and she might have shown the consultants up a bit, occasionally, possibly. They could have had some personal wranglings with her, but Lucy said she thought she had a good working relationship with them. So I don't think that's true. It's just not enough in my brain. Correct me if I'm wrong, people in the comment section, but that is not enough to think of what the consultants are putting on the line. They're taking enormous risk to say, right, we think this nurse is a serial killer. You don't go around making accusations like that because, oh, look, she's shown us up a bit. And, oh, yeah, we don't like her that much. Although Lucy thought that they did like her and Lucy thought she had a good working relationship with them. So they had to genuinely, in my view, they had to genuinely believe what they're saying. That's just my opinion. We can't prove it one way or another, but in my estimation, they must have believed Lucy Letby's bumping off babies. It's making the neonatal unit look bad. We need to investigate this, and they just became obsessed with it. That's my belief. Why can't she sue the prosecutor in civil court? The reason is because the prosecutor has prosecutorial immunity. It's bordering on impossible to sue a prosecutor. They have immense protection and they're allowed to do virtually anything. As long as they don't go in there with paraffin and set the court on fire, they'll probably never get in trouble for anything that happens in a courtroom. One problem with the prosecution barrister giving knowingly false assertions to the jury is the so what problem. Is there a process for dealing with this other than the defence complaining? How often do the defence complain in the UK? How often do barristers who practice at the same chambers complain formally? The legal establishment doesn't brook dissent, and if you're employed in it, you will just make problems for yourself. Given the disgusting salaries they pay themselves and general lack of moral fibre, don't expect this to change. So firstly, you've made a statement at the end of that question that is difficult to disagree with. Generally, broadly speaking, the legal establishment doesn't welcome dissent, as you put it. And I do agree that it seems to me from my experience and my observations that if you are a kind of uppity character, you are making problems for yourself immediately. So I mentioned a little bit earlier in the video this pre-trial meeting they have. I personally, morally and ethically, find that extraordinary. That the defences meet with the prosecution, say, okay, we'll discuss this, we'll discuss that, we won't discuss this, we won't discuss that, etc., etc. I would be as antsy as possible in that meeting. I'd be like, we're not agreeing to that. We're going to put everything we possibly can in the case, and I'm going to hammer you in court. So we don't know what was taken out of the case. I don't think there's any way to find out. But it seems to me that if you're the kind of person that is difficult, you are less likely to rise up the system, and you're less likely to become a King's Counsel. I don't have definitive proof of that, but I think most people will agree with that statement, apart from the King's Counsel themselves, who, we were talking about self-serving views earlier. I'm sure that they would disagree with that for self-serving reasons. So we're talking about knowingly false assertions. Is there a process for dealing with this? I just mentioned this about prosecutorial immunity. Basically, so you go on to ask this question about the defence, how often the defence can play in the UK. So I have yet to encounter an instance of Ben Myers objecting during the court case. It doesn't happen very often. It's not like the movies. It's not like seemingly the US system. You don't directly object to the court. You don't stand up and say objection like they do so dramatically. Like at the end of Goodfellas, for example, is one. That doesn't happen. You have to object to the judge. I have seen one example of Nick Johnson objecting to something, and it was pretty much upheld by the judge. So I don't know how much that happens, but it seems that it doesn't happen very much. I hope to get some criminal barristers on the channel and ask them questions. So if I manage to do that, I'll ask them and they can give a view on it, and they will give a much more informed view than I can. But nevertheless, it's not difficult to see that it doesn't happen very often. I can't really comment on the same Chambers question, but I know the point that you're making, and you're suggesting it's a bit pally and a bit matey. Hard to disagree. Again, I can't really prove that, but I think there is both nepotism and cronyism in the criminal justice system and in all walks of life. So it's not unique, but it's very, very difficult. Ultimately, the ultimate answer to your question is almost exactly the same as the previous question. It's very, very difficult to hold a prosecutor to account unless they do something absolutely outrageous. So it really is up to the defence barristers to say at the time, Judge, I don't think this is correct, I don't think this is fair. And if they don't do that, you're screwed. But it seems that this happens far less in British courts than it does in American courts. So this is kind of the same question. How many objections did defence make in this case? What were the most relevant? How many defence legal assistants and interns worked on this case? So having looked this up myself, I have found one objection from the defence, which was on the 22nd of March, 2023. That doesn't mean that that was the only objection in the court case, because we don't have everything available, but based on the court reporting and transcripts that are available, that's the only one we can see. What we can say confidently is there were very few objections in the court case, so I can't answer the question of what were the most relevant, because we just don't know, but objections played almost no part in this court case. I can say that quite confidently. In terms of how many defence legal assistants and interns worked on this case, this is just simply, unfortunately, an impossible question to answer. The only way to answer this question will be to contact the legal companies involved, and they just simply wouldn't tell us. So there's just no way to know. But there will be, I would assume, assistants working with solicitors, etc. But as to how many, we just couldn't answer that question. Could any of the three arrested managers be persuaded to pursue a wrongful arrest case? It could be useful to bring matters to a head. It could be a crowd-funded case. So I think there's a few problems with this. Firstly, we don't have any easy way of contacting the arrested managers. Secondly, I'm very doubtful they would be receptive to this because they will naturally be scared. Firstly, being arrested is scary for any reason, I would imagine. I've never been arrested, but I'm sure it's not very pleasant. If you're arrested in relation to very serious accusations, I'm sure it's terrifying, particularly when you know other people have gone to prison. They're just not in a situation, unless they knew, they'd have to have absolutely cast iron proof that they had there was a wrongful arrest. Taking the police on something like this is extremely difficult. The police always have their ducks in a row. The police know what they can do and they know what they can't do. The police have the power of the law on their side. So to pursue them for wrongful arrest is very difficult. It's perhaps not quite as difficult as the prosecutor that I mentioned earlier, but you've really got very little chance. So a crowd-funded campaign is just not going to help. The money would just dissipate and disappear. I just don't see that is something that is even remotely feasible, unfortunately. I must say, let me just finally say, I hope the executives can be exonerated as quickly as possible, and I hope they're not arrested again. I hope they're not charged because they've done nothing wrong. Do you think we'll ever find out the extent to which this was a purposeful frame-up? What I mean is, can we know beyond conjecture whether the people involved truly believed in the prosecution case or not? My opinion tends to be that the police were convinced in a wrong-headed and foolish way that they had the right woman. When it comes to the consultants and Dr. Evans, I'm less sure. I can't help but wonder how many of these individuals actually thought they'd found the perfect scapegoat in Lucy. I can only speculate, but I wonder if we can ever get a fuller sense of the picture. So firstly, I've already given my opinion on the police and the consultants in this video. I believe that the police thought they were correct, and I believe that the consultants thought they were correct. In terms of Dr. Evans, I wouldn't like to comment for legal reasons. In terms of whether we'll ever find out the extent to which this was a purposeful frame-up, I think this is a brilliant question. Can we know beyond conjecture? I think the answer is no. We can never truly know. One day there might be a big inquiry and investigation into this, but even the inquiry and investigation can never truly find out, because the only people who will ever know in their own head are those that were involved. It's very much like Lucy's case. I've said before, I'm 99.99999% certain that she's innocent, but I can never be 100% because it's just simply impossible. Like, I wasn't there at the time. Some of these things that you can't 100% disprove a hypothesis. You know, you can look at the balance of evidence and say, well, everything's pointing to innocent, therefore I believe it to be innocent. And I've said that strongly in my previous video. And I'm happy to go on the record saying that, and I'm happy to go on the public stage and say that. But I can't say I'm 100% certain, just as you can't say, no one can, people do, but you can't say you're 100% certain of guilt because it's just rubbish. How can you when it's hypothetical? How can you when it's based on theories? How can you when there's no concrete evidence? It's rubbish. You can't ever be certain, and equally, we will never be certain unless one of them, the only time you'd know 100% is if someone just said, fair enough, I never thought she was really guilty, I just did this maliciously. Unless that happens, we'll never know 100% because they can say, I genuinely believe Lucy was guilty, and that can be true. But we'll never know what's going on inside their own brain. You know, I was talking with my friend today about The Invention of Lying, the film made by Ricky Gervais, which I think doesn't quite sustain. I haven't seen the film, but to me it's one of those films that doesn't really sustain a feature-length narrative, but is an interesting idea, an amusing idea. But unfortunately, in this world, we've invented lying, and lying has been around for a long time. So I'm not saying anyone is lying, but obviously they can lie, and we can never know if they're lying or not. So I don't think we ever will know for certain. But obviously there could be a legal process, and that legal process could conclude that people were deceitful. That's feasible. But we'll never truly know, in my estimation, unless someone confesses, which they won't. Can anyone please list what evidence is present that shows her guilt? Especially or specifically, anyone who is still convinced that she is guilty can help with this. I keep asking, and apart from furiously maintaining the verdict was correct, they never say anything. People keep talking about a retrial, but why would they retry her if the evidence does not seem good enough to even charge her? So that's one for people who believe her to be guilty, because I don't believe there is evidence that points to guilt. I believe the complete opposite. So if you're watching this and you believe Lucy to be guilty, please bring up the critical evidence that you believe points to that. Thank you for another fantastic video. I really do appreciate all of your support for Lucy. Any advice for your viewers with regard to how we can continue to support? Done letters to the King, MP, etc. Signed petitions, would love to do more. A very difficult question to answer because societally it's made as difficult as possible. So I'll tell you a quick story. So someone contacted me via email and said they'd written to their MP, as this person has done. And they showed me the letter the MP had written back, which was the typical stonewalling generic letter that you expect. So she said, I believe it was a she. I think I'm remembering correct. Yeah, it definitely was. She said to me, what do you think I could say in response? And I said to her, what you should say to them is, okay, fair enough, you're not going to do anything. What should I do? I'm very concerned about this. What do you think I should do? And they basically said, they did make one suggestion, which I think was to contact the Ministry of Justice, like as if that's going to help. But apart from that, they basically said, you should follow the case closely. How does that help? We are following the case closely. Following the case closely has achieved nothing. I mean, it's raised awareness, but in terms of a concrete step that we can put in place that is going to expedite this case being dealt with, following the case closely doesn't do anything. So that's how useful it was writing to the MP. It's very, very difficult. And it's very, very difficult for me to give you tangible, credible advice that will make a difference. There's two things I will say to you. The first thing is, don't underestimate the impact that we've had, not me because I've done very little on social media, other people doing grassroots activism, spreading the word on social media. That's been enormously effective and enormously successful. Secondly, I'm going to mention in a forthcoming video, when we've got it all set up, some things that people can do. So a significant portion of that video will be dedicated to revealing this thing and seeking assistance from my viewers. So I will break that whenever I can, and I will tell you what you can do to help at that time. And that could be quite soon. Not related to this topic, but do we know why the DPP blocked the original statistical analysis? So this was the Crown Prosecution Service, not the DPP, just to clarify. I understand there was a Freedom of Information request made. Seems an odd thing to have done unless they were deliberately trying to avoid further exposure to the state of the NHS. So Professor Richard Gill told me that they did this because they think juries can't understand statistics. The problem is that they allowed statistics into the case anyway, but they were just really bad statistics. So I don't think it was necessarily malicious. Based on what I've heard, there was a reason for it. It's just yet another disaster in this catalogue litany of disasters that occurred in this court case. Was the neonatal unit of the Countess of Chester demolished? So as Michelle Warden has now confirmed, it has not been demolished. She lives in Chester. It is due to be demolished this year, I believe she said. So it is not currently demolished. I've also done a tour on another video that you can see online where I took people through a tour of the Countess of Chester. So yeah, the neonatal unit is still there at this point in time. My question is, considering most of these babies were subject to post-mortems, how come the pathologists who carried them out were never referred to or had any say during the trial? Did they just roll over and accept the post-mortems were rubbish? So basically, the court has the power to overrule the pathologists if they choose to do so, which they did. So the prosecution chose to overrule them, Dr. Evans chose to overrule them, the court didn't stop them from doing that. So at that point, the pathologists cannot do anything unless they're called to appear in the court case. So I'm sure they 100% believe in what they did. And then a lot of pressure was put on the Thirlwell inquiry to say various things, but it's not a case of them rolling over. They did the best work they could and they didn't believe this would come to anything, and then it did. And then once the legal system is involved, your work can be overturned very quickly. And if that happens, unless the defence call you, or unless the prosecution call you, your opinion is then meaningless. You've just been overruled. And legally, there's just nothing you can do about that. You just have to accept it. It could be very, very painful for you. You could cause you professional damage, conceivably. I don't think it necessarily would, because it's not your fault. But there's nothing you can do. Ultimately, I'm just repeating myself. There's just nothing you can do. So that's all there is to it. At what point did Neena Modi contact the defence? Was it too late? Had the trial started? So my understanding is, she hasn't confirmed this explicitly, but certainly my understanding is that she contacted them before the trial took place. As to why they ignored her, we still have not had a satisfactory answer to that question. That was another massive blunder by the defence. I am interested in the legal rules process to cast aside the finding of a coroner's court. Well, I can explain that to you. It's very simple. If the police investigate a crime and they decide, right, we're going to overrule the coroner's court, they can do that. They have the power to do that. They would then build a case, as occurred in the Lucy Letby case. They then refer the case to the Crown Prosecution Service. The Crown Prosecution Service undergoes a two-stage process. The second part of that process is to decide whether or not pursuing the case would be in the public interest. If it is a major court case with major crimes, they will almost always conclude that it's in the public interest. In Lucy Letby's case, immediate, because there's murder, death of infants. It's not even a two-stage process. It's really just a one-stage process. The first part of the process is the Crown Prosecution Service looks at the evidence, despite the fact they don't really have any scientific qualifications, despite the fact this is very difficult for them. I would say they're just simply not fit for purpose in doing this. And they basically go through the evidence, and if they believe that there's a 75% chance of this person being convicted in a court case, then they charge the person, or they give the... I'm not sure of the precise process of whether they charge them or the police charge them. As far as I know, they just hand it back to the police and say you can charge them, and then the case goes to court. And at that point, once the Crown Prosecution Service greenlight the case, bye-bye coroner's court. You don't matter anymore. That just completely overrules the coroner's court. That's all there is to it. When the pathologist was doing the post-mortem, was he aware that a needle had been put blindly into the abdomen? No, is a simple answer to that. That is still a matter of some contention, but assuming for the sake of argument we believe that is true, then no. He would have surely read the clinical notes before he started and not just relied on the limited clinical information on the PM request form. Did he speak to the clinical team responsible for the neonate's care to hear what happened? Was this a hospital post-mortem or a coroner's post-mortem? Did any of the clinicians attend the post-mortem to try and see why the baby had died? I've only listened to half your video, so you may have covered some of this. So I probably did, but I'll go through the questions anyway. So firstly, this is again child O. So because there's a subcapsular hematoma, that has been cited by the pathologist and by Jane Hutton, neonatologist, and they both may have believed that this is just so significant they don't need to go around looking for anything else, or it overruled any other issue in the case, and there might have been a little bit of uncertainty, but because there is this very serious medical condition at the heart of it, by the time they got to the end of their work, they couldn't see any other cause, and they didn't feel the need to go any further, which is what would probably normally happen. Now, I'm not a pathologist, so I don't know 100%, but I think that's quite likely. I don't know what happens in terms of speaking to the clinical team. It would be very difficult to find out that information. If the pathologist feels the need to do that, it would be usual for that to happen, I believe. But if the pathologist doesn't see the need to do that, they wouldn't speak to the clinical team. So because of the subcapsular hematoma, it's possible the pathologist... So when Jane Hutton's reviewing the cases, firstly, she's not speaking to the consultants, because her job is to speak to the medical director and the executives. So she's interacting with them. She doesn't have any contact with the clinical team. So there may be circumstances in which she would speak to them, but I think it would be more likely this would be relayed through the executives who contacted her initially. Like, she is ultimately answering to the hospital executive's medical director, so she's answerable to them, so she would contact them. as far as I understand it. She wouldn't go to the doctor just randomly go, hey, can I ask for your opinion? So that if she doesn't see a reason to do that, and if she speaks to the medical director and they don't see a reason to do it, that would be a reason why you wouldn't speak to the clinical team, for example. Was this a hospital post-mortem or a coroner's post-mortem? I'm not sure that's entirely clear, but as far as I know, it's a hospital post-mortem. Does coroners involved though? I'm not sure. Don't quote me on that. I don't know the answer to that question. That's a very difficult question to answer without doing a lot of research. And even then, I may not find out the answer. So I couldn't say 100%. So please ignore my previous answer to that question. Did any of the clinicians attend the post-mortem to try to see why the baby had died? Very doubtful. I don't think that would be normal practice. And you know, if the clinicians had made, let's say the clinicians had behaved maliciously, or had made a major mistake, you can't have them interfering in the post-mortem. So that wouldn't be normal practice, and that just shouldn't be allowed, as far as I understand it. Again, these are complex questions for someone that's not a medically qualified person. If you listen to this and I make any mistakes, if you have any corrections, if you have a different opinion, I get loads of medically qualified people. I mean, I'm amazed by how many I get. I'm really grateful for that. Pick me up on anything that I'm wrong on. I want you to mark me as harshly as you possibly can, because it's important that we always get the details correct. But I think you just simply would not allow a clinician to attend a post-mortem unless there's a very good reason. But I could be completely wrong about that. But it just seems to me that if they had behaved inappropriately or incompetently, why are you allowing them in there to just give their view? It just seems it should be an independent exercise, surely. This is just an enormous case with huge implications for both the legal and medical systems, I agree. I just can't understand why the CPS did not do due diligence before Dr. Evans gave his evidence in court, or did they just want to get the case across the line? Well, we can't make that accusation about them wanting to get the case across the line. We have to assume that they did their due diligence. I think the answer to your question is that it's not the job of the CPS to critique the experts, it's the job of the police. And by the time the police hand it to the CPS will just think, there is a suitable expert, let's look at the quality of the evidence, and they did that, and it met their two-stage process that I've just mentioned. This question isn't really a question, but I just wanted to address this because it's really important. So this person wonders how Lucy's being treated in prison. So I watched an interview with a guy called Peter Tritton, who was a Category A prisoner who smuggled cocaine into the country, and eventually he ended up being in prison in Latin America, which didn't sound like a lot of fun. I mean, it was crazy. Stories had were incredible. But he explained what it's like to be a Category A prisoner. Excuse me. And he said there's a veil of security around you. Like, you can't do anything on your own. You can't go to the toilet on your own. They protect you. That's Peter Tritton, who at the time was a minor cocaine dealer. It got a lot bigger for him later on, but he was in prison in Britain. So Lucy is literally the highest profile prisoner in Britain at the moment. So there will be an enormous veil of security shrouded around her, because if anyone gets to her, if she was killed in prison, for example, the embarrassment for the prison service would be enormous. So there will be a very stringent veil of security shrouded around her, and she's on a protected wing. She'll remain on a protected wing. She may be on a protected wing all the time she's in prison. It's very unlikely she's going to be in the general prison population. She's safe. She's as safe as she's going to be in prison, realistically. And I must say, I've heard a few stories about male prisons. Women's prisons are not as violent. Clearly there are violent people in there. Clearly it's dangerous, but male prisons are on a different level. So I think she's about as safe as you could hope for in a prison. So this is about whether we think Lucy will need a new identity. How will she cope with being in society? I would like to be anonymous. So there's a strong argument for this, but I will say that Kathleen Folbig's not anonymous. What's her name? Amanda Knox is not anonymous. So Lucy may be able to lead a normal life. I don't know. There's going to be a period of adjustment, that's a certainty, and it'll be very difficult for her. But she may be able to resume. Clearly, she's not going to be a nurse, but she may be able to resume a normal life in this country to a certain extent. I don't know. Or she may think, you know what, Andrew Malkinson, exonerated after being in prison for rape for 17 years, completely innocent. He said, "I just simply don't want to live in Britain anymore." And at the moment, he's travelling around the world. And who could blame him? It really depends on the individual. I think if Lucy said, "You know what, I don't like being recognised, I don't want to be recognised, I want a new identity, I want to go and live in a foreign country," that could probably be arranged for her. She's going to be one of the most high profile people in the country, and the most high profile ex-prisoner ever. So there's arguments on both sides. We'll just have to wait and see. I can't give a definitive answer. I think I would want to leave Britain if it was me. Whether I'd need a new identity, I don't know. It's weird to think, you get used to your name, don't you? And then you'd have to take on a new name. But I can imagine, my name's really boring, so no one would even know who I am. They're more likely to recognise me, so I don't know. But it's definitely a reasonable thought, and it could help Lucy to have a new identity. We'll see. So, did Moritz and Coffey ever attend the secret briefing events that the CPS and Cheshire Constabulary held during the court case? No one knows the answer to this question because it's classified, but I would say it's very likely that Judith Moritz attended them. I don't know this definitively. Have they had any additional briefings or meetings with the police or the CPS since the retrial? This is not something that would be revealed to me, and it's not something I believe that they've revealed publicly, so I can't really comment, but it would surprise me if they hadn't, but I don't know. Is it right to say that juries consider only evidence put before them? If so, then if that evidence is inaccurate, misleading or defective in any way, then that would affect the verdict. That's fair to say, but if the court accepts that as evidence, then you've got a really hard time overturning it. It needs to be shown to be legally wrong in some way. If it's just a bad argument, then it's very difficult to remove that from the court case. That's just the way the system is set up in this country. It's crazy, but there you go. Would it also be true to say, if the jury had access to all the data about the case, that is data with the best research done, etc., this would bring the jury to a more accurate conclusion? In my opinion, the decision to incarcerate a person for life is too serious. So I obviously completely agree with everything that you're saying, and a consequence of this is that we need to examine how to get better evidence, better scientific data, better science in court cases on a consistent basis. That's very clear. There has been an institutional reluctance to change the system, as I've discussed in previous videos, and it's going to be hard work. It's going to be tough to change the system, even though clearly the Law Commission recommendations should be enacted that were written in 2011 or published in 2011. It's always hard work to get the government to do anything because they just think, well, we've got a system, we'll just keep our nose out. It's not a problem. But there needs to be a concerted campaign to do this. You're absolutely right in everything you say. The fact is, this is the system we've got. This is what happens, and the government are too busy trying to do other things, so they don't. They would deny the fact they don't care, but I would say they're just perfectly happy to carry on with things as they are, and they don't want to get their hands burnt or their fingers burnt. In my mind, the person most responsible for the excess deaths is the lowest ranked person who could have shut the ward after the second severe sewage issue. So this person asked several questions about this. Do you agree with this, and if so, who is it? Brearey or Gibbs, or an executive, or someone even higher? So we discussed this previously. I believe there is an onus on the medical professionals because they're the people on the unit, they see the unit, it's up to them to communicate this to the executives. So I stated in the previous video that I don't believe the executives should be held primarily responsible. Someone disagreed with that in the comments, who's worked in a hospital and works in a hospital now, I believe, and they said there are systems in place for the executives to monitor the hospital. It's not that they have to be on the unit all the time. They should put systems in place to understand a picture of what is happening in all the units and make decisions based on this, so they cannot be exonerated from blame. And that's they know better than me. I can't disagree with that, obviously. I still believe fundamentally it has to come from the medical professionals first because they're on the unit, they're there all the time, they see things. So ultimately, I don't think it's the lowest ranked person, it's the highest ranked medical person on the unit, which is the paediatric lead, which is Brearey. So I believe he was the paediatric lead at that time. I think that's correct. So if whoever the paediatric lead is should have said, look, the sewage, we need to do something, we need to do it now. That is essentially what Dr. Evans said when he was interviewed by John Sweeney. That is literally the most sensible thing that he said in all of his interviews. I've noticed that severe sewage issues seem to occur after deaths. Goss also mentioned this when he poo-pooed the plumber. Do you think there is much of a correlation? So I think it's fair to say there is a correlation. I haven't investigated this statistically in great depth, and I'm not naive enough to think that I'm statistically qualified to do this, unlike the police. I think that anyone would say you don't want sewage in a hospital, you don't even want it in a normal residential building. In fact, you don't want it in any building apart from a sewage treatment plant. So it's hardly surprising you're going to get correlations with sewage being on the unit. I've entertained several theories as to why this correlation is there. If you do think there is a correlation, why do you think it is? Simply because it's extremely dangerous to have sewage on a unit. We know there's links with sepsis and pseudomonas that are also present on the unit, and it's neonates, they're very vulnerable, they don't have fully developed breathing. What do the Americans say? Do the math. It's pretty obvious why you'd have a correlation in my view. Do you think it's strange that there was a long period from 6th of October to 26th of January when the plumber did not get called out but 7 babies died, or are my plumber visits records lacking? I haven't looked at this in depth myself, so I can't comment on whether your plumber records are accurate, but if you had a long period where there's sewage and no visitations from any estate manager or anything like that, then it's not surprising that you could have suboptimal outcomes for infants on the unit. It's not strange. It would surely be expected. I don't think that's in any way unusual. When looking for more dates of deaths to refine my theories, I noticed that the unindicted babies' dates of deaths have been suppressed. Why was that done? So a very simple answer is that you're not allowed to say anything about these babies due to medical anonymity. They must remain anonymous because nothing about them must be revealed due to Hippocratic oath. Does this come under? I don't know, but there's no way we can ever find out any details about any of those infants other than the minimal amount that's been revealed. That's the simple reason. Hi Chris, I know this is completely off topic. I was just reading a post on Facebook about the nurses who did not speak up to support Lucy because of a fear that it would impact their career. I just wondered out loud how so many of the players appear to have completely ignored the professional duty of candour that they are required to deliver on the NMC code and the GMC good medical practice standards. So without going any further to this question, I think quite simply this doesn't come under their duty of candour as far as I understand it. So firstly, just to confirm for people who don't know, the duty of candour is essentially related to patient care. Fundamentally, it's about being open and honest with patients, I think also parents, when there are problems with care. So I think, as far as I understand it, if you didn't speak up with concerns, or if you had information that could exonerate someone, then it would be wrong not to speak up with it. And if you were dishonest, that would be a problem as well. The problem here is, and there's problems throughout this court case and throughout this whole debacle, is that how do you defend someone against non-specific allegations that are hypothetical that no one has witnessed? So people were supportive of Lucy at the time, and they were supportive even in their statements to the Thirlwell inquiry. But how can you, if someone said, right, Lucy Letby did this at 8:53 p.m. on the 12th of June, she attempted to, thrust an item down a baby's throat. That's what happened. If one of them could have said, well, I was in that room with her at 8:53 a.m. and she didn't do that, then in those circumstances, if you, as far as I understand, if you didn't speak up, then that would go against your duty of candour. However, that wasn't the situation. The situation was these vague allegations, and they did stick by her as much as they could, and they did support her, and the nursing team supported her and all this, but they weren't withholding relevant information. All they could say is, well, I've never seen her do anything wrong. I don't have any suspicions about her. So on and so forth. They can't like I said, they can't disprove something that is just a general feeling of disquiet or general allegations that are not specified. All that they can disprove would be a specific allegation about a specific incident, and then they would have a duty of candour and they would have a professional duty to speak up. But you can't speak up about something that is a phantom, that is vaporous, to use a word that I've used before. What can you say? I don't think there's an easy answer to this question. If there'd been very specific allegations, they could have done something. If you don't have specific allegations, what can you do other than say, well, I like Lucy, which is what they did say. Can the parents of the baby sue those doctors based on this evidence, or are they prevented from doing so because Lucy's in prison for murdering them? Because in the eyes of the law, the moment they became aware of this knowledge, they have a right to make a claim. I feel so sorry for them as the truth has been hidden from them. So there's two aspects to this. Can they literally do it legally, and can they practically do it? So I'm not certain whether they can literally do it legally, but I don't think anyone can prevent... Someone did give an answer to this question in one of the comments, but I still think they could probably sue the doctors or sue the hospital or whatever it is, right? That's fine. The second question is, would they win when Lucy Letby is in prison for murdering babies? And the answer is no. You'd have an incredibly hard time. It's not easy to sue someone for this type of thing, and naturally they're going to be lawyered up to the eyeballs, and their lawyers are going to say, but someone else is in prison for this. You can't possibly hold my client responsible because Lucy Letby got 15 life sentences, and you're just not going to get anywhere. All you're going to do is end up paying the expenses for both sides. So at this point in time, there's no chance. But whether you could do it illegally or not, I believe that you possibly could, but I could be wrong on that. But practically speaking, it doesn't matter, because unless you just want to throw away a lot of money, there's just no point in doing it, in my view. And I'd be very, very surprised if a legal expert would say differently, because you'd need to reach a very high standard of proof, and the defence for the people you're accusing are going to say, but the person's in prison, have you not noticed? And the last question I'm going to answer is about a question that was from Michelle Warden about, and I will ask this to Michelle as well, but I wanted to just answer this question quickly. In her experience, are babies more likely to collapse at night or not? So I have found a study which indicated that there was quite a significantly higher number of babies that died at night. Now, I don't know if that's has any real significance. It can just be a coincidence, of course. But I did speak to one nurse, and she said it's quite commonly known for like midnight to be described as the witching hour in nursing, because it's when things tend to go wrong. And maybe that can be because less people around, I don't know. But there is some both anecdotal and academic evidence that suggests babies are more likely to collapse at night. There is at least some indication for this. So the last three questions are about sewage. Now, the reason I put them there at the end is because I don't know the answers to these questions, and without a lot of research, I can't tell you the answer. So I'm going to put them on my list for my next Q&A, which is bound to happen because people ask me questions all the time, and I will address them in the next Q&A. That's a pretty tricky question, and I want to make sure I get my facts right. So I will address them, but I'll do that in the next Q&A video. So finally, I'd just like to once again express my gratitude for the incredible support that I've received, all of the comments, kind remarks. It really means an enormous amount to me. It's such a wonderful experience to make something that people value and to see the same names coming back, and to build a real community of people that support what you do. And I know that's maybe 1% to do with me and 99% to do with how important this is and how much we care about Lucy's well-being. And indeed, this case ultimately isn't about Lucy Letby, it's about whether or not you can have a fair trial in this country. We should never lose sight of that. Obviously, what's happened to Lucy is awful, and we want that to change, but this really is about whether or not you or I if we're innocent of something, can know that we will get a fair trial. Because at the moment, I'm sure we're all aware that is not guaranteed. It's far from guaranteed. So I just again wanted to make the usual plea. If you could subscribe to the channel if you're not already, that's very helpful for me. Makes my videos more visible. Numbers have gone up to an incredible level. I mean, I'm blown away by the support. It means a lot. And it's helped in some small way. Maybe it's helping Lucy's cause. That's certainly the aim. It's certainly making me, I suppose, more of a known presence in the community, and that will help with the book that I've mentioned. As soon as I can give more details on the book, I will. There's some stuff happening. As it's turned out, it's worked out well, because now I can, because I didn't publish it early, which I could have done, I can respond to Moritz's book, which I will, and I can tweak it, my book, a little bit to do that. So I have the ability to do that now, and the possibility, capability, capacity, however you want to describe it, for doing that. But yeah, if you're not subscribed to the channel, if you could please subscribe. I mean, it's going up rapidly, for which I'm really grateful. If you can comment, I mean, I get hundreds of comments. I love reading your comments. I always try to respond. I try to respond to at least 80%, maybe more. I do the best I can. And liking a video is also valuable. So if you can try to remember to like the videos when I post them, that's really helpful as well. But yeah, in the next few videos, I'll be going back to Panorama and looking at some of the details that have come out. I've been prepping some stuff for that, so that will follow in the next few videos. I just wanted to do this Q&A while I could get it done in under 1.5 hours, which I managed to do. So yeah, any comments, queries, corrections, etc., please leave them in the comments section, and thank you for watching.